But this subject is common law arbitration, where common law, aka due process, actually happens. And this is presented by urlaw.org, and you must be a premium member to get more of these details. As a matter of fact, you need to almost be a mortgage member or a member using the Slam Dunk program to first see this when we first release it. But over time, it's going to be available to more of our members as we put more test cases out. We can't take on everyone at one time, but we can take a few cases that are running right now and put this in because it's a very quick process relative to other processes. Now, I want to stress that if you've watched some of the videos we've put out over the years about common law, subrogation, bonds, all that, well, guess what? It all is relevant to this subject because the reality is everything is contract. And you're going to see some examples of that here in just a minute. But everything is contract. And so once you get it to that objective level of understanding, you'll have a more effective way to deal with what's happening. You're being pulled into contract arrangements. And so I'm just going to go through this document. It's about a 5-page document. There's much more to go through. This actual document is much closer to about 80 pages, but I'm just covering the overview tonight. And then with the additional videos that we're going to do, it's going to cover more of the material. It's not very hard. It's really a very simple process, but if you don't understand the background of it, and you're asking me questions, hey, well, what do I do next? What do I do next? Then I know that you already should know the answer to that because we'll have already given you those steps, and you have to follow through. We cannot be here to answer all your questions. It's just not possible for me to do that. So I want to be sure we give you a good, thorough understanding tonight in this video, and then as we release additional videos and the materials, and you read those materials, then and only then will I listen to questions, because if you can't already answer the question, we haven't done a good job of putting it together. This is going to become self-explanatory once you get the concept. So tonight my goal is only to give you that big picture. But here's the bottom line. Most of us lose when we go into our public courts. It's about a 98% chance of losing. I don't know if you know those are the odds against you. Okay, so it's not good. Why is that? Well, I'm going to explain it, and I think it has to do with us violating a basic law of, well, really commerce. And so our goal is to move out of their public courts and disputes and maybe even get out of jail. As a matter of fact, so far it's proven that this process could get someone out of jail if you follow through correctly. And then normally I would tell people once you've gone to jail, your chances are really, really slim. But here's the key. There's a rule in law that says subject matter jurisdiction can be challenged at any time, even after conviction, making it void. That's why we have a void judgment course. But this is going to help you do even that strategy better. So pay close attention. But if you're facing a criminal charge, this is even more effective. If you're dealing with a mortgage, it's perhaps in foreclosure or facing foreclosure, and you're either a judicial case or a non-judicial case, we're going to give you some ideas here as to what you can do. Those of you who are in our mortgage class are going to go through much more detail on this next week on that training. We're going to go into specific details how to do a mortgage if you're in that class. That's a special enrollment in addition to the premium membership. Details are on the premium member page. But the bottom line is you're dealing with foreign parties and you're falling under congressional rules. Congressional rules or jurisdiction. And if you understand Congress, they don't regulate you and I unless the matter falls under international or interstate commerce. And what they've done is they've written a set of laws that are so broad that they almost all fall under interstate commerce. We wonder, people make a lot of sovereign arguments that, oh, my God, you can't touch me because this, that, and the other thing. However, if they can pull you in under international interstate commerce laws, they can. What we have to do is point out to them that we understand the rules of the game. And this is the nexus. This is something that so many people have missed when they fall into these courts. They say, I want my common law jurisdiction. I'm going to convert the court to a common law court. That is not a realistic way to look at this. But you can notify the court that you understand that you're dealing with a commercial matter at all times, even if it's so-called criminal. If you don't believe me, let's just open up this little link right here. to 27 CFR 72.11. And I think it's going to become self-evident what's going on, how they pull you into congressional authority, even though you can say you're a state citizen all day long. You can say I have a passport that's a state citizen passport, or all these sort of things. They might help you, but if your activity brings you under this jurisdiction, you're under it. That's why it's so hard to get out from underneath. But I'm going to show you a way to fix it. But if you look at meanings of terms under 7211, 27 CFR 7211, as used in this part, unless the context otherwise requires, terms shall have the meanings described in this section. Okay, I'm going to skip this part. But what they talk about here is what falls under these terms fall under this jurisdiction: ATF officer, appraised value, carrier, and by the way, that's vessel, vehicle. Anybody even accused of traveling with a motor vehicle and driving under the influence? That's because, and if they get you into their court system, and even if it's a state court, they're pulling you in under the Interstate Commerce Clause. Okay, and let's go here because they don't clearly define what a vehicle is here, but they sure seem to think your car is one. But here's the big one: commercial crimes. Any of the following types of crimes, federal or state. Okay, start there. Offenses against the revenue laws. Ooh, you're offensive. Burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale of property of deadly weapons, prostitution, including solicitation, procuring, pandering, white slaving. I don't know about black or brown slaving, if that counts now. That's old stuff. Keeping house of ill fame or like offenses. Extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if it were a commercial crime. Commercial crime. You guys want to memorize this term. If the word commercial crime falls into the conversation at any point, or directly or indirectly, this is how congressional authority and its laws affect you, even at the state level. But what if you're not engaged in any commercial activity? Or what if there is a commercial activity? You know what also has to go along with every commercial activity? A contract. And I don't think any of you have probably had a contract, many of you at least, to those issues. So a commercial crime requires jurisdiction and a contract. A truly criminal matter in the court must be an Article III court. And they don't give you that, even though it's the Constitution says it's a court of general jurisdiction. Now, versus being a commercial court of, sorry about the typos, this is just my notes, limited jurisdiction. And when they pull you into state court or U.S. courts, these are limited jurisdiction courts. It doesn't mean they don't have authority. It means they have limited jurisdiction. The limited is they can only deal with commercial matters. You think that, wow, DUI, how's that commercial? Well, because it involves a vehicle, which is a commercial thing. You got it? You have to see how these words pull you in. And it's not just your status that gets you out of these things. It's your activity and the lack of proof of activity. You already have your status. So all matters that end up in federal state court technically involve interstate commerce, which is how these congressionally approved courts gain jurisdiction. They do have jurisdiction up to a point, but they can lose it, and that's what we're going to focus on here. See, you've always had a right to arbitration to ask for it. Why? Because, well, I'll show you in a minute. I'm going to get to that in a minute, why that's important. So commercial courts must grant this right once raised. I bet you've never raised it. And we'll be able to show you in some of the more advanced training, we're going to show you court cases where the courts have said, oh, if there's an arbitration clause or if there's a matter that's still in dispute, like a commercial contract, and the contract is verified to be true, the courts lose jurisdiction. Don't you want them to lose jurisdiction at some point over you? Well, then you have to bring up the right matter the right way. So what happens is everyone skips over arbitration. But I can tell you, skipping over a step that should be part of the process, it will cause you all kinds of problems procedurally. And they're not going to tell you that it happened. They're just going to do it. And this is why I believe 98% of us lose our cases because we skip from talking to our enemy to fighting with them. And there's supposed to be, and is, and always has been, the right to arbitration. Again, I'm going to give you a historical reference, and there's more than I'm going to give you, but this is just one I'm going to give you in a minute. So here's what we're going to do. This is what I'm going to basically teach you, and then I'm going to give you a background for it. A criminal case where jail is a threat, okay? Not so much small traffic cases. I mean, a small element of this might apply, but really those where they've taken you from a civil traffic matter to, oh, you assaulted the officer, or, you know, you really didn't, but there was no real harm, but, you know, or you DUI'd or something like that, and you didn't cause a serious harm, although you might be endangering people, you still didn't cause that harm yet. Or if they're already in jail and going through a criminal trial now, this needs to include this new conditional acceptance notice that we're going to help you prepare. Those are in the slam dunk. I will be emailing you the link right away so you can start on this first as our test cases. And it's not going to be like you're a guinea pig. I mean, you're going to read it and go, oh, well, this makes sense. I'm going to do this. It won't hurt anything. So anyway, we're indicating due process was violated. Once due process is violated, as we've taught you in our deficiencies training, then jurisdiction is essentially something you can challenge at that point. So you have to have a reason to challenge jurisdiction. You know, they don't necessarily have it until you bring it up in the right context. You can't just say, I challenge jurisdiction, ha ha ha. No, you have to kind of show them that they've lost it, and therefore whatever they're doing, whether they're trying to do it or they've already got a judgment, that it's void. Okay? Again, if somewhere in their documents they use any of those terms you saw listed at 27 CFR 7211, it's an interstate commerce matter. That's the only way they get jurisdiction. And you have to show them that, well, I'm not engaged in interstate commerce, so prove otherwise. And that's part of the process. There's literally a 400-point demand you give them. It's really well developed. So we're going to send them a new contract, okay? And we're going to develop the contract. And if they don't deny the contract, it is a true contract. And then arbitration is going to determine that the contract is valid. Once you have a valid contract, the court loses jurisdiction because it should be settled in arbitration then. The courts might fight you in some cases, but generally speaking, they've got to follow their own rules. These are the rules. Mortgage foreclosures. All these involve interstate commerce and thus require arbitration as to the contract in dispute first. Okay? Now, they usually don't do that. They just come after you and start going after your house, right? They either do a judicial process and sue you, or they do a non-judicial process and just try to take it. So we have to intervene and stop this. This is a much simpler way than even what we've been teaching in the mortgage class once you see how this lays out. Okay? But we want to make them cease and desist, bring it into a common law arbitration versus going through their public court system and losing the house, which is what's going to happen 99% of the time. Okay? Again, it kind of falls under these commercial commerce clauses. This is the tricky language they've used on this. It's all commercial commerce matters. Therefore, Congress can create their rules and spread their rules outside the borders of the District of Columbia. Now, you can say it's not constitutional or whatever, but you understand the Constitution gives us essentially a right to contract, which means once they extend the contract and you don't stop the contract, then they do get jurisdiction. Contracts are the supreme law. Okay? So you do get pulled into these things, but there's a way out by recontracting. We're going to show you how it's done here. So remember, Congress writes the law. They're all commercial in nature. They can only regulate what's going on in the District of Columbia and interstate or international commerce. Again, the study material I'm going to give you has plenty of references on this. But for me, the big one is Matthew 18, verses 15 through 17, and actually through 20. You must know what these mean and what they were written for. It is a commercial instruction. Now, whether you're what type of Christian you are, however you interpret the Bible, I'm just here to tell you that these are laws, and they matter, and the courts recognize it, and it's where due process essentially, I don't know if it originated there, but it certainly was clarified there, whether you agree with that or not. It's there. And it's like gravity. If I pick up a pen and I drop it, it's going to hit the floor every time. It's a law, a natural law. And this process describes natural law, how matters should get resolved. And if you follow it, it works very well. But if you skip it or you break it, for some reason we always lose. And I think that's why we're losing our cases, because we don't understand this. So we're going to get into a very practical way to do this. Is we have to learn to do what's called conditional acceptances. And I say it's a common law. Arbitration is the procedure. And again, that'll show itself here in a moment. But if you want to look at the source, and I'm going to try to give you sources for everything that we talk about. And again, in the training that we're going to do ongoing on this, we'll have even more links so you can do your own homework. You don't have to ask me. But it starts off, and I got this was at the U.S. Catholic Bishops version of the Bible, where they explain things a little bit more. You can get various versions out there, but you know, to me, I like to go more to the original source, and they tend to have the more original versions. King James or this one are good versions to go with. You'll see that it says essentially the same thing. So in this is again Matthew 18 and verse 15. If your brother sins against you, and they added the word against you for clarification, go and tell him his fault between you and him alone. If he listens to you, you have won over your brother. Ladies and gentlemen, that's called just talking to somebody and working it out. That's always the first thing, and so many people forget about that. That's the best remedy for most situations. Talk to them. Work something out. Okay? 16. This is the biggie. This is the one everybody goes right past. If he does not listen, take one or two others along with you, so that every fact may be established on testimony of 2 or 3 witnesses. Now, you could look at this different ways, but I'm telling you, if you procedurally skip this step and you go to court, they're always looking, they're going to ask you, have you exhausted administrative remedies? This is administrative remedies. Courts follow this. Why? Because it makes sense. It's just good due process. Whether you think the court's corrupt or not, they still tend to lean on the due process procedures. And if you don't get too far off in sovereign land and patriot land on them and simply just bring them down to the procedures they have to follow, they tend to comply. They follow commands. I learned a lot of this in the self-help lawsuit course, that you don't have to get off on some of those nonsense issues. Just simply focus on what they're supposed to follow and hold them accountable, and there are proper ways to do that. So it says, if he does not listen, take 1 or 2 others along with you, so that every fact may be established. When you're sending things through a certified mail or priority mail with confirmation of delivery, maybe even having a third party send it and receive the documents for you, they become a witness to what your efforts to communicate a process. Okay? And what we're going to do in this process is we're going to send them a conditional acceptance offer that becomes a contract if they default. It becomes a new contract. We're no longer debating their contract now. We're not debating anything. We're accepting everything as long as they can prove that it still applies to us. After they look at everything, and by the way, these conditional acceptances are written in such a way that they're full of actual case laws and laws. In other words, they have to prove that it doesn't say that, when we know it does. And therefore, it releases us from liability. And therefore, that becomes the contract. Hope you get that. We send them a conditional acceptance of all these various laws and rulings and facts that they're compelled to pay attention to. And if they cannot dispute what we know is actually true, then they agree that then they have no jurisdiction authority in our matter and should release and cease and desist, or whatever it is they're trying to do, get us out of jail. Okay? And this is a process. This is essentially arbitration, because at the end of sending these documents, you're going to go to an arbitrator, and we'll show you how to find one, and they're going to review your process. So now you get another witness that has some sort of official stamp of arbitration that they can put on. They don't have to have a special license, but they have to be independent, and they give the certification that all this happened and that the contract, the new contract you created, exists. That's all they do. They don't determine the right or wrong of the arguments. They don't care about the facts of your case. They just want to know, did you send this document through? Did they essentially agree by their default? And they really have no choice, because how are they going to argue against what the law actually says? That's all we're asking them to do. then you now have a new contract, a new agreement. All they're certifying is that, yes, there's a contract here. Now, there's a contract, and the matter is resolved. You cannot go to 17 if that's done first. Once you bring it in and you notify the court that it's already been resolved in arbitration, basically the court loses jurisdiction because you're not giving it to them to resolve because it is already resolved. And you're not going to them with this other matter. You're going to them with your new contract, a resolved contract. That's going on offense. We've talked about this so much, but this is a non-judicial way to establish an offensive move, if that makes sense. So if he refuses to listen to them, tell the church. And these days, what we're talking about here is the court, because churches were a place where these things were used to be heard. And if he refuses to listen even to the church, then treat him as you would a Gentile or a tax collector, okay? An outsider, somebody who's violating you, all right? And that's court. These rules, you can't break them. I don't care whether you believe in the Bible or not. You probably find similar versions of this in other writings, but this is the one that seems to have the greatest foundation. So I'm just telling you, the Bible is the best law book ever written. And if you simply follow a few rules, it will protect you, whether you believe it or not. It's like gravity. I drop a pen, it's going to hit the floor. Or I can make an airplane that will defy gravity for a short period of time, but eventually it's got to come down. Okay, these are natural laws. They just work. And all this did was codify how to get things resolved in ways that proved to work, called due process. You want common law? Ask for due process. That is common law. So then I'm going to read on just the last two because I think they're still relevant. Amen, I say to you, whatever you bind on earth shall be bound in heaven. That's a contract, folks. Binding is a signature to promised future performance. So whatever I bind on earth shall be bound in heaven. So in other words, if I do it right in an earthly way, I get the spiritual support as well. In other words, I get the law of the universe working for me. Okay? Whatever you loose on earth shall be loosed in heaven. So be careful, if you're going to screw things up, it's probably going to affect you now and forever. Okay? However you interpret this, but to me that's what it means. It's about binding and bonding. Bonds are contracts. Promises to do something. When they put you in jail, they put a bond on you. Again, amen, I say to you, if two of you agree on earth about anything which there are to pray, it shall be granted to them by my heavenly Father. Again, how do you interpret what that means? What does heavenly Father mean to you? And of course, to Christians, that means to their Lord, right? But what if it also means that that Spirit is within you, which is apparently what we were given? Okay? In other words, you'll be at one, you'll be at peace, and you'll come to peace. Isn't that what we all want? And then for where two or three are gathered together in my name, I am in the midst of them. So once again, if you're working together with people, maybe the arbitrator is your third person, your second person, your third person, and you're working together for a peaceful conclusion, because that's what this is about. When he's in the midst of you, that's called peace. Isn't that what you want? This is to me, the most important section of the Bible because it tells us how to fix all our problems. And arbitration, common law arbitration, getting out of their system and doing it through a third party, through private contract, when they also honor private contracts right out of the Constitution first as the priority, then why aren't we doing that? So, that's the premise for what we're talking about here. When you skip and you fight, that is to plead guilty or even not guilty, you're fighting, you're giving your grants, you're turning it over to them to decide. That's what you're doing. You've skipped over arbitration. And you think, well, how does that matter to a criminal matter? Again, you have to go to 27 CFR 72.11 and understand that Congress only can authorize commercial act crimes over interstate commerce, and anything that involves commerce can be arbitrated. And we're going to show you a law that also shows that that exists. And we're going to show you, again, not maybe all tonight, but some examples of how Congress agrees that arbitration does apply to our commercial matters of all nature. Okay? So tonight I'm not trying to prove it all to you. I'm just trying to give you the 30,000-foot view, but you're going to see more as we put more of the material out and go over it. So I came up with the term myself: conditional acceptance, arbitration, common law arbitration. You're going to find it. Their contracts always have defects, and all you're doing is pointing out that there are major defects in these contracts, like warrants and search warrants and mortgages. They all have defects. We've talked about how to do that with syntaxing, and that could be incorporated into this as evidence, by the way. But this is just the process to close the deal, okay? So I want you to put it in this context. See, they have the ability to zero the account, and a criminal case is an account as well. They start with a charge, a bill. It's all accounting. And sort of mortgage issues and lawsuits and everything else. So once initiated, the process was not granted upon demand. That is your arbitration process. Once you've established that there is a fact in law, which is contract. A fact in law is contract. You have created a new binding, and notice I kind of highlighted the word binding, okay? Binding contract with them right out of up here, whenever you bind on earth. And then using the authority you have. So you have the authority as we always talk about being a private citizen versus a U.S. citizen or something like that. Yes, we have to act. If we want to be seen as a man, we don't just say it. We perform it. We prove it. We don't have to say it. They already know it. But we have to bind it, show them that we understand our procedures, what we have the ability to do, and we have to take charge. So we have to go on offense without going into their courts. And if we do go in their courts, we need to have it already resolved. And that's what we need to do before we begin. We've got to get the arbitration step in there and bring it in. That pulls the jurisdiction away from the court. Once they see a contract, and I've seen plenty of case law on this, and again, we'll cover it in future trainings, once that contract is seen by the court, they'll say, well, we have no jurisdiction at that point because it's already resolved. So we do this conditional acceptance contract type of offer. Then you take them to arbitration. You ask them to zero the account because they have no more claims, and then basically they can do what's called ledger offset credits they created when they opened the account. And if you actually go into the collection, again, I need to get some people to send me their documents, but I haven't looked at some in a while, but I've seen enough others. But when you have a mortgage or a credit card, they'll tell you that how they zero the account and charge it off. Where do they get the money to zero it? Have you ever wondered? Well, this is the way to do what's called a set off. People think you go to the Treasury and you tell them to bring the money over and pay it. No, that's not how it works. You actually have them to take the credit they created when they opened the account, because they created a credit on one side of the account to then issue you the money on the other side of the account. They had to have the credit in place because they have no money. When you read Modern Money Mechanics, you understand they have no money. They have to just create a credit with your signature, your application, and your note. Then they issue the money out of the separate account. Well, guess what? That credit's still there. All we're saying is use the offset credits to settle the account. That's part of the process. It's not the entire process. See, in the system of bankruptcy since 1933, everything has been prepaid to your future promises to perform. You must invoke this, though. In other words, they realize they're out of money, so all they could do is say, well, if people will sign promissory notes, we'll come up with this clever way to put money on account and then lend it back to them. That's all they do. And but the thing is it's already prepaid. You prepaid it by you created fictional money out of a fictional document, so pay off the fictional debt. Okay? I'm not saying be irresponsible. I'm saying do the accounting, and you're not being irresponsible. So if the debt is due, they'll zero the account. They'll send you a 1099, making you liable for a tax on it, so they get extra money credit off that. Actually, that's a credit to them. And then they sell off the bad debt again and collect from you again and again and again. Sometimes they send it to 2 or 3 debt collectors. But they've already been paid. The account was zeroed because the money was already there to pay it. I hope you get this. It's a hard concept. But the credits were created right on the ledger when you sign the contract. The fiction money is made once we sign or answer also a complaint. When we answer a complaint, we say guilty, not guilty, give our name, whatever it is. We've come in and said we'll be liable for this bill that you created. And they have a ledger too in those courts. And everything there is binding, they bond you to 10 years in jail, whatever it is. It's a contract. So let's take some of that insurance money that we created. Essentially, that's what we did, is we insured it with our signature, and use it to settle the accounts. And give them a whole bunch of other reasons to show that whatever contract they've created has major defects, because I wasn't engaged in interstate commerce, so how can this apply, and so on. So again, I already talked about this, how you can kind of zero the balance on a credit account. And by the way, this document, these notes will eventually be put up on the site as well, so you'll be able to read some of this. But here's what we must do. We must conditionally accept their offers. I've been saying this for years, but now we're giving you a very specific roadmap about what to do when they're chasing you. So invoke your right to set it off and create a binding contract for arbitration before they can proceed. And if they have proceeded, to void what they've done. Okay? So if you're dealing with a court matter in their commercial courts, then that's a congressional issue, and Congress says we have a right to arbitration. It's interstate commerce, and there's some level of arbitration rights there, because it's a contract when they give it to you. So what we're going to do is we're going to give them a contract as an acceptance. We're going to accept, but give them a contract. Well, we will be happy to settle this matter once you resolve these various issues. One of the contracts you're going to see has almost 400 different citings. Every single one of them are right out of the law. And all that we're saying is, tell me that it doesn't say that. Tell me that it doesn't say this. And of course, it does say that, right? And if they now agree, which they'll have to by silence, well, then we have a new contract, and our arbitrator is going to settle the matter. Now, let's look at this also from the perspective of the 13th and 14th Amendments. Again, Congress has got to follow these rules, right? Aren't these their rules? Who cares if it applies to you or me? It does apply once a contract is in effect. But if there's no contract or a valid contract, well, then that's our way out. 13th Amendment, Section 1. I'm not going to read all the sections. Neither slavery nor involuntary servitude, except as punishment for a crime whereof a party shall have the duly convicted shall exist within the United States or any other subject to their jurisdiction. Bottom line is involuntary servitude. They can't force you into these contracts. And again, crime is actually a commercial crime under 27 CFR 7211. 13th Amendment, Congress shall have the power to enforce this article through appropriate legislation. And by golly, they did pass appropriate legislation, and it has to do with Article 9, which I'm going to show you a link to. Let's see if I got that link here. Yeah, it's down here. I'll get to it in a minute. 14th Amendment, all persons born or naturalized in the United States. Now, we're not going to talk about that the United States is in the District of Columbia and all that. I want you to see how the contract part works its way in here. All persons born or naturalized in the United States are subject to the jurisdiction thereof, and subject to the jurisdiction thereof, sorry, I'm going too fast, are citizens of the United States. Now, if you've done your research, citizen of the United States is somebody who lives in the District of Columbia or the territories. But we're not arguing that here yet, okay? Or of the state wherein they reside, and state actually means United States. Anyway, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So they can't make laws that abridge their immunities and privileges. One of those privileges, folks, is contract. Okay? The state, that means any state, or the United States, cannot create laws that abridge the privileges and immunities of citizens. Contracts create immunities. Privileges are created by contract. You see, you understand what this is saying. So, nor shall any state deprive any person of life, liberty, property without due process of law, nor deny any person within its jurisdiction equal protection of the laws. And equal protection means if I have a contract and you have a contract, we have to determine who has the real contract. I get equal protection. If there's a contract, such as an arbitration agreement or a right to an arbitration agreement, they cannot interfere with that. And the courts, this can be used in court. Section 14, Section 4, this talks about the validity of the public debt of the United States authorized by law, including debts incurred for payments of pensions, bounties for services in suppressing insurrection or rebellion, shall not be questioned. but neither the United States nor any state shall assume or pay the debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, claims shall be held illegal and void. So you can't enslave people. You can't work them into contracts that enslave them, but contracts do matter. And if somebody else works against you, they're committing insurrection and rebellion. So we're going to learn how to use this language to our advantage. Go look up the Commerce Clause. It's under Article 1, Section 8, Clause 3. Write that down. Article 1, Section 8, Clause 3 of the U.S. Constitution. It gives Congress the power to regulate commerce and with foreign nations and among the several states and with the Indian. Okay? Now, what does this mean? Okay, if you're doing business outside of the District of Columbia, you are foreign. And the several states, which we assume means, again, we haven't looked this up here, but we assume that might mean, in this case, the Union States. But also, you are an estate. You have an estate. It's in your name. It's the all-capital letter name. At least that's how they try to slip it in on you, folks. They call you by the all-capitals name. They're presuming that it's under this clause right here. And that's how they pull you in. So we're gonna rebut that. Okay? You have to rebut it. Again, Congress has often used the Commerce Clause to justify exercising legislative power over the activities. This came right off of the website Cornell Law. Congress is just a comment they wrote, but it's interesting they wrote this comment because we all hear about it all day long, and they call you a sovereign citizen for bringing it up, and there it is on their website. Congress has often used the Commerce Clause to justify exercising legislative power over the activity of states and their citizens, yes, leading to significant and ongoing controversy regarding the balance of power between federal governments and the states. Darn right they do. That's a big problem we have. And then, of course, they create private corporations overlaying all this, which your state and your legislature and all these people have done. The courts, federal and state, are commercial enterprises. Then the Commerce Clause has historically been viewed as both a grant of congressional authority and a restriction on the regulatory authority of the states. So this is what we're caught up in here, folks, this dilemma. The only way out I've seen that really makes sense is use their commercial power against them. Use your enemy's weapon against them. The art of war, right? So let's create a new contract that works in our favor rather than work under their contracts in their courts, in their commercial courts, doing commerce. We need to rebut those presumptions, okay? Doing time. Okay, we're going to move it along here and try to get some questions. In 9 U.S.C. Chapter 1, go look this up, please, because this goes into way more detail than I'm covering tonight, but you need to read it carefully. Remember I said earlier, the Congress shall pass laws essentially to support this theory, and it is the FAA, the Federal Arbitration Act. And please understand, even though you haven't seen a written contract from maybe your lender that talks about this or from your criminal case, it does exist because it falls under commerce, generally. And we have the right to create a new contract with them before we proceed. Matthew 18, verse 16. Then there is an arbitration clause in our contract. And we want that right. If they don't rebut it, then they agree that we have that right. That's the logic of the agreement you'll see. Again, I'll cover the agreement in a separate video at some point very soon. This is probably the next one we do, is going through the contract. But it's so much information. It's literally 100 pages of conditions. And they're all legitimate. They're not just made up out of thin air like a lot of people do. You know, it's really made up based upon actual laws and rulings. And they have to prove that they don't exist. So go look up this, just search for it, 9 U.S.C. Chapter 1. You'll see a ton of information about arbitration and what the rights to arbitrate are. And it won't be always seen clear, because remember, they don't always use clear language. But the rules of arbitration, they're charter parties, which essentially are government agents that say we're not a class of worker, but we are. Well, we also are a private citizen. But as a group, we are a class. Okay, a little confusing, but don't worry, you'll get it. So if their courts come after you, use arbitration as using a conditional acceptance, creating a new contract to make your determinations of a firm contractual relationship, and of course your right to arbitrate, right? And once they default, you've already won. And by the way, you can also, it's interesting to read this one, the United Nations Rules on Arbitration. You can go to unicitral.un/text/arbitration/FAQ. I'll pause here if you're watching a video version. You can write that down. But read what the UN says about arbitration. Why does the UN, how does that have to do with Congress? Because Congress also, when they put that international clause in there, they're recognizing that for us to do trade, we have to have a relationship with international bodies, and therefore, that's commercial trade, subject to arbitration. Okay? So I'm going to move on, but everything is contract, folks. Everything is a contract. So we need to start dealing with everything as a contract. And if we don't have the contract we feel is right, we need to create one. And that's what our conditional acceptance contract does. Okay? And again, I wish we had a little more time tonight. I would start getting into one of the contracts, but I will do it in a separate video. So if you're a premium member of UR Law, it will be put there first. And you can go to that new training section and review the contract and actually read the contract. I'm not going to post the actual contract yet until we get it in the hands of a few of our personally coached members, people who are doing coaching and consulting first. We wanted them to actually put it together and help us work out a few bugs before we put it out to a larger group. Otherwise, we're going to have a mess. Too many people with too many questions. We will have already proven it, and then we'll be able to show you in a little more detail. But we're getting very, very close. Maybe this video, if you're watching it later down the road, it's already happened. There's another website you should make a note of. Go to arbitration.nation.com, arbitration.nation.com, and learn a lot more about what is arbitration, how does it work. You know, we're not just making this stuff up. Well, all we have to do is get a contract together that it qualifies. That's all our only goal with this whole process. It's very simple when you actually look down at what you do. It's about interstate commerce, international commerce, that kind of thing. Commerce, crimes, okay, 27 CFR 7211. You're going to get that one memorized. Remember, Congress approves the courts. They created the courts, state and federal. If Congress approved it, it falls under interstate commerce, and therefore are commercial, and therefore are subject to contract. If there's a contract that's proven, arbitrated, and already in the place, they lose their jurisdiction, though, because they understand commercial law. Admiralty, commercial law. Maritime, commercial law. They know that. They know what it is. We don't have to bring it up, that point up to them. All we have to do is show them we actually have a different contract. That's what we're going to do. We're going to teach you how to do. So they really can't enforce these commercial matters against a private man or woman unless that woman has specifically engaged in interstate commerce, which to some degree we're going to, using a new contract, though. And that contract becomes the supreme law. All right? That's very important to get. And then, once we have that contract established, jurisdiction can be challenged easily because the court no longer has a matter before it that's not already resolved. Why would you have a court if the matter is already resolved? We're not going to go to court and talk about their problem. We're going to talk about our contract. That's the power position we take. All right? And if you go into court, it's not going to be really an argument. It's just a matter of, does this contract exist or not? And of course it will, because we will prove it and have it arbitrated on top of that. There's no place for them to go. We're closing all the gates. So at that point, using their courts is nearly impossible. Otherwise, we're probably going to lose because we're playing on their field under their rules, and we don't know the rules. Okay? So people talked about for years getting to the private side, the common law side of the court, all that. We've just shown you where it is. It's Matthew 18, verse 16, doing a contract, getting it privately arbitrated, and then walking in with that in hand. And if you got something going on, you do this. It takes only about 15 days to set it up. You can put a cease and desist on whatever else is going on. Again, because you can show that there's an arbitration contract in place. And we don't necessarily need their overt agreement because the law says that it can also be through silence. And we definitely cite that in the contract and the law, and they can't deny that it exists. Okay? So you look up this Severability Doctrine. That's in the Arbitration Nation. So we have to ask the question, what commerce are we actively engaged in when driving, just personally? I didn't say using a motor vehicle or a vehicle, paying taxes, or doing a commercial, involved in a commercial crime where there's no actual physically harmed, I mean victim. Okay, you can't repay them somehow. If you know it's stolen from them, but you should pay them. That's what this restitution should be. So when we're receiving an indictment or a sentencing agreement, which is, if you've ever read a sentencing agreement, it's all contracts, boy. You know, if you just look at it carefully. So we have to conditionally accept and demand arbitration. And we produce the arbitration actually before we even get them to agree or not agree. They don't have a choice once the arbitration is done. It's already a resolved matter. So we create an irrevocable agreement as a private citizen. You want to give me 15 different ways you can tell the court you're a man, or actually show them how a man does his business. I'll take the one where I prove it by my action, not by my words. So you're going to learn, by the way, when you're reading some of this, you can learn about classes of persons. A class can use once established in a contract. You know, that's an important term when you get into some of the study on this. So look for words in if it's a charge or a bill that relates to interstate commerce, like a bill or a charge or, you know, a violation of some statute. Those are all jurisdictional issues. They all have to do with commerce. Therefore, it's a commercial term and subject to even an indictment, because an indictment is a true bill. Have you ever looked at them? Bill's a bill, boys and girls. So arbitration applies under the Federal Arbitration Act. So remember, courts are just corporations formed by Congress. They admit it. Big deal. If that's what they are, then let's treat them as such instead of making a big protest about it. So what we do, here are the steps, and I'm about done here. What we do is we give them a notice with a contract offer. It's a conditional acceptance terminology that's used throughout this document. We conditionally accept that you have the authority if you can show me that this law didn't say this and the Supreme Court really didn't say that. And it goes through a sort of a negative averment type of approach. You send them the contract to the primary party. Maybe, for example, if there's a court involved, you send it to them first. And then secondary parties, maybe the attorneys. And then you'll send it all over the government. You send it to all the agencies, the governor, if it's in the state, attorney general. You hit all the basic agencies, the legislature. You let them know that there's an arbitration matter that the court is stepping on. And they regulate these courts. So you got to let them know that you've got a matter that should be heard, and there should be a cease and desist in the courts. And we give you a list of ideas. We're going to come up with more extensive lists here of who to send it to. But first of all, of course, if it's a court matter, send it to the court. If you're already indicted and in jail, you still go back to that case number to that court. It still exists. The bond is still there. Okay? You know. And then you send a final default notice after you send this first contract through. It takes about 10 days. It's only a 10-day window. And then a 72-hour notice is sent last of default, given them 3 more days, and then let them know that now the contract is in effect. And that's just how the law works, folks. Law of contracts. So then we order arbitration via recommended arbitrator, which we will give that information out privately to our members, particularly those in coaching first, and then we'll release that information as we go because we don't want them getting overwhelmed. They will not answer your questions. All they do is the arbitration. You have to send a form, and you send them a check for their services to do arbitration. It's really not that expensive, less than $1,000 probably for everything you have them do. But remember, you're getting this out of the court. How much is that going to cost you? So then you just send through, basically all they do is do a confirmation that you sent these documents, you didn't get a response, that the notice of default went out. And all the arbitrator does is says, oh, yep, this was done, okay, yes, you have a contract. Now it's a settled matter. And once you have it settled, well, let's do a little enforcement. If it's a judicial court case, you'll enter a judicial notice of the arbitration ruling. and a cease and desist order. You tell the court you lost jurisdiction and you must cease and desist. It's not an option for them. They might fuss about it, but the rules are the rules, folks. And I've always said, hey, use their rules against them. Stop arguing. And if it's a non-judicial matter, like a non-judicial foreclosure, there are, of course, judicial foreclosures, but if it's non-judicial, we have to do a little extra, maybe file, and we're going to have to play with this a little bit, that you're going to file a lis pendens, most likely, which is a notice of an action, essentially. But you'd say, because it was already in arbitration, it's already resolved, and here's a copy of it. Of course, you copy whatever it's about, right? You get that recorded in their court. And then I would even go as far as possibly going and opening a miscellaneous filing in the U.S. District Court near you. And the reason I do that is it's easy to do, but it also puts it in the federal jurisdiction if you have to take this across state lines, and you will. So why not just get it recorded? People wonder, how do I get something recorded? I can't record it at the county recorder. They won't do anything. Well, if there's a court case, they will file it. But just blindly recording something, no. But if you create a miscellaneous file in the U.S. District Court and then get a certified copy out after you file it with all the stamps and everything on it, that's admissible evidence anywhere. See, what you're not doing is creating admissible evidence to bring it into the other case. So that's another good way to get it all pre-recorded and then bring it in. They can't reject it. You may not have to do that in a state case, but I do this in either case because I want to bring it into state or federal. If I already got it created, they can't keep it out. Once it's notified of the court, and there's basically a default, the court simply says, well, there's nothing we can do, you've got now a judgment in a private jurisdiction that's recognized, and there's a notice that goes in with this miscellaneous filing. It's a notice of a foreign judgment. Once that's in place and nobody disagrees, it's all a fact of law now. Now people have used UCC filings, filed liens, and done writs of execution, all this stuff. But if you don't have this in place and attached to it, the UCC-1, to place the lien, then you could run into problems with that. But with this, nobody can dispute it because it's already been contractually decided essentially by the court. It's been recognized by the court. It's recorded in the court, in their courts, but it's also recorded privately. There's nothing more the court can do with it except to release the prisoner, except to stop the mortgage action and to release it, whatever it is you're deciding. And if you file a UCC-1, that's a lien. And now, though, you're filing it with all these documents attached with real authority. This is how people do private law instead of going into their public system. And then a writ of execution, essentially an order, maybe to the sheriff or whoever, to go pick up your stuff. Now, that's a remedy, folks. And I'm just giving you all the steps. Now, we're going to give you the details in a separate video coming soon. But I think that's pretty cool. And I have to thank some people online that put some stuff. There's a guy on YouTube called Eon, E-E-O-N, I think. And he had some videos. They were a little hard for me to follow, but I did stay up with it enough, and I got some notes. And then I did some additional research on my own and in terms of some of the enforcement steps. So I think we're on to something. As premium members of UR Law, you're going to eventually get all this. As if you're currently a coaching member, you're going to see it first. If you're in the mortgage coaching or the slam dunk coaching, we're going to want you to put this contract out right away. We will be sending you the contract shortly. You just fill it out and start sending it to the primary parties. And as you learn, you'll figure out who else to send copies to. But you got to get the process engaged. I think we're going to see a lot of remedies with this. I have a feeling the courts aren't going to be real happy that we sort of figured out the way to nullify them. But nullification is actually a legal process, and that's all we're doing here. We're keeping it out of the court. We're doing them a favor, taking the burden off the court, having to do all this. So anyway, folks, that's basically this part of the presentation.